Sex offender issues are forever a balancing act. Everybody wishes they could crush the sex offender population out of existence. But I gotta tell you, it's more delicate than that. If sex offender restrictions ever cross the line from being regulatory to being outright punishments, then there's a loophole of law called the ex post facto clause, which would make the scheme powerless to affect any past offenders. Only the new cases could be bound by the rules, while the whole mass of earlier cases would be exempted, turned loose. Now you might say, forget that loophole and do it anyway, stomp them all. But this ex post facto thing, it's built into our United States Constitution. And if we start poking holes in that, we all go down together on that ship. As a matter of fact, people are questioning whether the current Adam Walsh Act restrictions have already gone too far in that regard. Ohio has taken the lead on this by its Supreme Court ruling that these laws cannot be retroactively applied to cases older than 2008. A separate question people have is whether the sex offender laws are effective enough to justify their cost, or for that matter, whether they're effective at all in meeting society's goals. I won't spend a lot of time analyzing both sides of this topic, but the costs are staggering and the concerns are valid. Not all of the costs are financial. These laws have caused heaps of collateral damage, unintended fallout, on the wives and children of offenders, and their home communities, churches, school systems, employers, and so on. Considering that fallout, one point supported by the very clearest of evidence is that we have begun to register too many crimes. We really should filter out the lighter cases. We got to refocus on the ones who set out to do deliberate harm to people. In a country built on Puritan ideals, we sometimes forget normal sexual impulses do exist. If we wanted to lock up everyone who ever had a scandalous thought or deed, well, that would really be everyone. But this registry was built to publish the super bad repeat offenders, only the predators, only the worst of the worst. Now, gradually, it's become a catch-all, and today it's diluted with so many mild cases, nobody can really get a solid reading on their true threat level. Hey, no matter how flawed the system may be, or how ineffective, American society is definitely not intending to repeal the Adam Walsh Act anytime soon. No, the masses are still rallying to add new safeguards and restrictions, just as fast as anyone can think them up. This topic is a political hot button, and a huge cash cow is not going away. The best we can do is to fix up the worst of the rough patches. So along these lines, I have written the following suggestions as an open letter to Congress on my personal website. You can find a link in the text of this CNN iReport. One basic problem that occurs when offenders move from state to state is that the states end up in a tug-of-war about the status. Lawmakers really must allow the state of origin to determine who is published on any criminal registry system. When the executive branch of government in another state overrides the status determined by a sentencing court which knew the facts, this creates a breach of full faith and credit, and of separation of powers, and a breach of common sense. And then, where multiple jurisdictions have gotten involved in the setting of someone's status, that offender has no clear recourse. Each agency points the finger and blames someone else for the wrongful status. There must be a single point of determination with a clear and accessible process of appeal. My second idea is that lawmakers have got to prevent any impact from these sex offender laws against the core, very essential human right of marriage. Specifically, Adam Walsh laws should not disqualify sex offenders from sponsorship of family-based immigrant petitions. Yes, I know, human trafficking, that's a big problem, and of course it's tragic if hopeful immigrants end up being exploited. I'm not proposing tolerance. Not at all. But petitioners should be examined and disqualified on a case-by-case basis for reasons of risk or fraud. These type of assessments cannot be categorically predetermined with fairness. If they were, the resulting blanket denials would wreak havoc upon every intended beneficiary, in addition to the targeted offenders, and the senseless collateral damage is just unacceptable. This portion of the Adam Walsh Act must be struck down. Now, last but certainly not least, here's the toughest bit to swallow. Lawmakers must realize that public humiliation of sex offenders on the registry is not equal justice under law, as carved across the stone face of our U.S. Supreme Court building. Consequently, America has got to choose one of these options. They must either build registries for every type of criminal offense exactly alike, or abolish the sex offender registry, or void the promise of equality. By facing these three specific constitutional challenges, we can actually assure that the sex offender enforcement remains fair and effective to meet this society's long-term goals. Because if we ignore these issues, sex offender laws could end up being struck down altogether, or nullifying the sacred Constitution which makes this country so great.